Good afternoon, Ms. Karabi. How are you?
Good afternoon. I'm well. How are you?
I'm good, thank you. Mr. Diebert is here. Do you need to take him into a breakout room? Whatever you want to do.
Sir, I can't pronounce his last name. T-Bert wants to speak to me. I have no problem.
Okay. Mr. Tiebert, do you wish to speak with the attorney?
Um,
Or ma'am, I'm
no,
sorry. I'm sorry.
it's okay. That's okay. Um, no, I'm still waiting on an answer from DHS.
Okay, thank you.
This is 2400217 LT. This is Huron Estates versus Billy Thiebert. May I have your appearances or state your name for the record, please?
Good
Billy
afternoon.
Siebert?
Thank you. Today is the day and time scheduled for the adjourned hearing in this matter. Ms. Thiebert, the court has received indication that you filed an application for rental assistance. Which
Yes, ma'am.
agency did you file the application with, ma'am?
DHS?
Have you received an update or response from them?
Not yet.
Ms. Karabi?
Your Honor, I don't know whether she applied. I wasn't present at the last hearing, so I apologize. I'm not sure if she submitted the DC form with you at the last hearing. But plaintiff wants to move forward with a judgment today. However, if she's applying for the assistance, I'll leave that to your discretion.
Thank you. She did, Ms. Lieber did file the 539 with the court on January the 30th. I saw it on a review of the file management system. Ms. Lieber will adjourn this matter for the last time. The return date will be February the 22nd at 2 p.m. When you return, please provide an update of
Yes.
the status of your application and be prepared to discuss the resolution or a settlement with the representatives for Huron Estates, okay?
Okay.
Was there anything else on behalf of the plaintiff?
No, Your Honor, thank you.
Thank you. Ms. Thieber, that concludes this matter. You're free to go. I will see you back here on February 22nd at 2 p.m.
Thank you.
Thank you, ma'am. Ms. Karabi, I know that you weren't here the last time, but a lot of these cases were adjourned because their service was not complete. We've since received copies of the proof of mailing by your office, and there had been court mailing, but there was never any filing for posting or personal service.
Okay.
And I don't know if that's a systemic issue starting from the initiation of the case or something in your office. But I'm seeing some of your tenants starting to check in. In addition to Ms. Thiebert, there's someone else in with the court clerk right now, so I'm not sure how we'll move forward with the service
Okay.
issue, but I just wanted to
So-
make you aware of it.
To clarify, so you don't have proofs of services for all of the defendants for Huron Estates?
We have mailing, but none of the ones for the 1 o'clock docket or the 1:15. And then again at 1:45, again, we're showing mail from your office and court mail, but no personal service or posting at the property. Same thing with the 2 o'clock portion of the docket.
Okay,
That was a conversation I had with Ms. Lacy when we were here on the 24th and on the 26th, the 26th. But
can you
Ms.
give me,
Augustinus is here.
oh, okay, that's fine. I can speak to her and then, I'm gonna go double check with the clerk and, I mean, the individual responsible for the service at our firm. See if she has any.
I understand. I know we're all still trying to work through the process of between on base and the new court rules. It's a little wonky sometimes, but I think we're trying to get there.
Hopefully by this year, we'll get there and understand it. We'll probably understand it when they change the court rules again.
Don't say that, not again. This is 2400187 LT Huron Estates versus Augustinus.
Yes.
Laura
State your
Kubiana.
names for me, please.
Sorry.
I'm sorry.
Hello.
Ma'am, state your name.
Wendy Augustinus.
Thank you. Today was the day and time scheduled for the second hearing in this matter. You've had the opportunity to speak. How are we proceeding this afternoon?
Your Honor, I actually have not had any opportunity to speak to Ms. Augustinius. If she wants to
Oh.
speak to me, I have no problem doing so.
I thought you were moved into that room. I'm sorry. Ma'am, have you made an application for rental assistance?
They just told me about submitting the form, the DC 539. I can apply for it. Yes, I do have some money and I have another check coming, but I will probably, and then taxes, of course, will come through, so I can catch it up. But I probably will apply for the rental assistance and do the form.
Okay,
'Cause
ma'am, then what we'll do right now is we'll move you into a breakout room. You'll speak to Ms. Karabi, who's the attorney for Huron Estates. And after you get done speaking with her, you'll come back into this main session, okay?
Okay, thank you.
Thank you. Ms. Carson, when the attorney comes back out, I'll call your case.
Okay.
Ma'am, have you made an application for rental assistance?
Yes, I have, Your Honor.
With what agency, ma'am?
DHS.
When did you make that application?
The day we had our last court hearing.
The 26th?
Yes.
Okay. And did you file the DC 539 with the court, the form that lets the court and the plaintiff know that you've made such an application?
No, I didn't know I needed to. I'm sorry.
No, no, it's fine.
But they said it was too costly for them to cover. That was the reason for denying.
DHS denied your application already? Okay.
Yes.
Were you expecting Miss Augustinus to come out of the breakout?
I'm trying to take her out.
Okay, sorry about that.
No worries. This
okay.
is a recall of 2400187 here on the stage versus Augustinus. The parties have had the opportunity to speak. How are we proceeding this afternoon?
Your Honor, as she had stated to the court earlier, she is in the process of applying for rental assistance and will be submitting a form.
Ms. Augustinus, is that correct?
Yes, ma'am.
Now, ma'am, what we'll do is adjourn this matter over to February the 22nd at 2 p.m. You have 5 days from today's date to file the form that's called the DC 539. You can find it on the court's website. If you want assistance in locating that form, filling it out and submitting it, there's court staff available. We can move you into a breakout room and you can discuss that with them. Do you need some assistance in getting that form filed?
I mean, is it just I fill it out? Do I pay any money or anything? Or is it, I mean, I could probably fill it out if it's self-explanatory, if there's directions.
It's a pretty short one-page form. There's just a few boxes for you to fill out.
Oh, yeah,
It's on the
fine.
court's website. It doesn't cost anything to submit.
Okay, no, I don't need any help then. Thank you.
Okay. Then ma'am, you're free to go. I will see you in the afternoon on February 22nd. Have a good day.
You too. Thank you so much. Bye-bye.
Thank you. This is 2400203LT. This is Huron Estates versus Autumn Carson.
Laura Kruger on behalf of plaintiff.
Today was the day and time scheduled for the adjourned hearing in this matter. Ms. Karabi, in your absence, Ms. Carson indicated that she applied with DHS for assistance and they've denied her claim. Ms. Carson, do you need the opportunity to speak to the attorney for Huron Estates?
Yes, may I speak with them because I am able to get the money on Monday.
Oh, absolutely. Let's get you moved into a breakout room.
Thank you.
Ms. Karabi, before you go, we also have 2400254LT ALF Investments versus I'm sorry, that's not your case.
No.
I won't give you more work. Thank you.
I appreciate that, Your Honor. Thanks.
Mr. Swadesh?
Yes, Your Honor.
How are you today, sir?
I'm doing well. How are you?
I'm well, thank you. My policy is about 15 minutes after the scheduled start time, unless you have some different update for your cases.
I have an update on the one who appeared 2 weeks ago. We have been talking and we spoke this morning, and she is not the tenant on the lease. She's an occupant of the property. It's her husband that's a tenant, and my client has agreed to enter into a new lease agreement with her only going forward. So for that particular matter, I think I would still need to take a default against her husband, who's the named lessee. And then I would ask the court to indulge us in a conditional dismissal as to the wife, giving her time to sign a new lease agreement with my client.
Can
So
we
probably
actually, this is, just so the record's clear, we're talking about 2400226LT Willow Country Estates versus Shepherd.
That is
Can we
correct,
really
Your
do a
Honor.
conditional dismissal to a non-party?
Well, she would be an occupant. I don't know. I don't want to. I mean, I spoke to her this morning. I don't know if she's going to appear today or not. She's an occupant, though. So the alternative, Your Honor, would be to put that particular case off for 2 more weeks to give us time to finalize that lease agreement. My client doesn't want to just dismiss it without having that new lease agreement in hand, because otherwise we've got to start the process over again. And I don't want to take a judgment for possession against her because we're agreeing she can remain in the house subject to the new lease.
I'm with you. I just wanted to pull up the file and I see now that it's listed as all occupants. So we could do it that way, the way you
Okay.
propose with the default and a conditional dismissal if
That
she
would be-
appears.
So, obviously we'd wait, 15 minutes on that one as well. But the rest, I haven't heard anything from.
Thank you. We're back on the record in 2400203 Huron Estates versus Carson. The parties have had the opportunity to speak. How are we proceeding?
Your Honor, at this time, the parties are in agreement for a consent judgment. Ms. Carson is planning on paying this in full by February 12th. However, we're going to keep the statutory writ date of February 19th, 2024. The rent to retain is $1,380.75 plus court costs of $195.44 for a total of $1,576.19. I did explain Ms. Carson's rights, and she has given me permission to sign on her behalf.
Thank you. Ms. Carson, you were here on January 26th and you watched a video that explained the rights you have available in this landlord-tenant matter.
Yes, Your Honor.
And ma'am, you also received a paper copy of that advice of rights when you were mailed a copy of the summons and complaint.
Yes, Your Honor.
And after reviewing those advice of rights, you wish to enter a consent judgment with the terms that were just placed on the record.
Yes, Your Honor.
Do you have any questions about today's proceedings or that proposed consent judgment?
No, Your Honor.
Then, ma'am, the court will adopt the terms of the consent judgment that were placed on the record by the attorney. The only change will be that the pay or vacate date will be February 20th. The court is closed on the 19th.
Thank you.
Anything else on behalf of Huron Estates?
No, Your Honor, thank you.
Anything else, Ms. Carson?
No, Your Honor.
You're free to go, ma'am. You have a good day. Good luck to you.
Thank you.
This is 2400224 LT. This is Willow Country Estates versus Nicholas Edmonds.
Good afternoon, Your Honor. Douglas Swadish appearing on behalf of the plaintiff, Willow Country Estates.
Thank you, sir. Today was the day and time scheduled for the adjourned hearing in this matter. The case was first scheduled for January 26th. We did not show service. The court has since received proof of timely mailing and posting by the plaintiff. Notice was mailed to the defendant to appear this afternoon at 1:15. It's now 1:30 by the court's clock. He has failed to appear. How would you like to proceed?
Your Honor, we would ask for a default judgment of possession only at this time. Service was made by posting. The total rent to retain possession owed is $13,900, which is inclusive of February's rent.
And court costs?
I don't have those off the top of my head, Your Honor, but I don't think it makes a difference at this point in time. There is no expectation on our part that the tenant's going to pay this to stay. So we're fine with the $13,900. If he pays that, we'll be tickled.
Understood, sir. The plaintiff's request for entry of default judgment is granted. Please submit your judgment by my file. The court will sign it. Anything else in this case?
No, Your Honor, that is it. Thank you.
Thank you. This is 2400225 LT, Willow Country Estates versus Shelby Michalak.
Your Honor, Douglas Swadish appearing on behalf of the plaintiff, Willow Country Estates.
Thank you. Same thing as in the previous case, sir. We appeared on January 26th, 2024. The court did not show receipt of the proofs of service. We have since received proof of mailing and proof of posting timely made. Defendant was sent notice to appear today at 1:15. It's now 1:31 by the court's clock. Defendant has failed to appear. How would you like to proceed?
Your Honor, the plaintiff would ask for a judgment, a default judgment of possession only. The total amount of rent to retain possession at this point in time, inclusive of February's rent, is $21,850.
Default judgment shall enter as prayed by plaintiff. Please submit it by on base. Thank you,
Thank
sir.
you, Your Honor.
There, Ms. Carmody?
No. Good afternoon, Your Honor.
Good afternoon. Good to see you again. This is 2400236 LT Huron Estates versus Stephen Carmody and Christine Carmody.
Laura Kubriana on behalf of plaintiff.
Ma'am, the last time you were here, you indicated that you'd be filing for rental assistance. You did file the form with the court. What is the status of your application for rental assistance?
She said you did file for, you said you
Sir?
did file for rental assistance. I'm sorry, ma'am.
Yes.
I'm
No,
sorry.
no, no,
I'm
listen.
just telling you.
No, sir.
Yes.
No, listen, we did this last time. It's okay if you talk.
Oh, okay.
We made it, yeah.
Oh, okay. Okay. She actually made a deal with the office, Your Honor, to pay a certain amount monthly.
I already paid it.
She has already paid $1,500 towards it.
Ms. Carmody? Karabi, I'm sorry, Ms. Karabi.
That is correct, Your Honor. The parties have come to an agreement for a consent judgment. She has already paid $1,500. The terms are as follows. The $1,400 will be due on the 3rd of each month until paid in full. And Ms. Carmody waives the 56-day rule, excuse me.
Okay, there has to be more numbers than that. $1,400 on the third.
I'm just pulling up the file, 1 second.
Yes, ma'am.
If Jessica can hear me, the property manager, the only terms I have were those, and I don't have the full amount, but I'm sure that she can assist
Yeah.
me. Thank you.
This is Carmody, right?
Yep.
Yep, so it's, the consent is 1,500 paid, due the 3rd of each month until paid in full.
Right. What's the full amount owed?
Hold on 1 second, I'll pull it up for you. Okay, for January's total, we have 24,1575.
Okay, we also need February's as well.
Okay,
Do
so
you need to
since,
go into a breakout room with your client,
That's,
ma'am?
yes, I really do. Please. Thank you.
Let's do that.
second of 1,500, so her back.
No, ma'am. No, ma'am.
I was just in the breakout room and then it went back, sorry.
Good afternoon, Mr. Ruard.
Good afternoon.
Miss McClinton is here. Do you need a moment to speak with her?
I'll be glad to speak with her, Your Honor.
Thank you, sir.
Hi. Can you hear me?
Yes, ma'am. Were you expecting Ms. McClinton to come back out, sir?
Yeah, I told her to just leave the breakout room and not the meeting. We
She's
have an
still
agreement.
there.
We have an agreement.
Then let me get her out. Hold on one second. This is 2400254 LT ALF Investments versus Carmen McClinton. Please state your names for the record.
Ronald Ruark, Your Honor, for the plaintiff.
Ms. McClinton, vote right. Oh, she lost her audio.
Yeah, I'm here. I'm here.
State your name for me, please,
I'm here.
ma'am.
Can you hear me?
Yes,
you hear me?
ma'am.
Carmen McClinton.
Thank
Okay.
you. Your
Carmen
agreement, Mr.
McClinton.
Rourke.
The agreement, Your Honor, is that she owes $7,100 in rent. This is possession only, and she'd be giving 15 days to vacate. So that would be what, the 22nd?
And this is in a consent judgment or a conditional dismissal?
Consent judgment, Your Honor.
Consent judgment. Ms. McClinton, you've had the opportunity to speak to Mr. Rourke, and you wish to enter a consent judgment that indicates that there's $7,100 due in rent and that you will pay this amount or vacate the property by February the 22nd.
Yes.
And ma'am, when you were served with the summons and complaint in this matter, it contained an advice of rights form. Did you review that advice of rights?
Yes.
Ma'am, do you have any questions about your rights in this matter or these proceedings?
No, ma'am.
And because you appear on Zoom, there is not a signed consent judgment. Have you authorized Mr. Rourke to sign your name to a consent judgment?
Yes.
Then ma'am, Mr. Rourke's office will prepare a consent judgment with the terms that were just placed on the record. He will file it electronically with the court. I will sign it and a copy will be mailed to you at the address we have on record. Anything else on behalf of the plaintiff?
Nothing, Your Honor.
Anything else from you, ma'am?
No, ma'am.
Thank you. That concludes this matter. You're free to go. You have a good day.
All right, good luck, Carmen.
Thank you.
Thank you, Your
Thank
Honor.
you.
Ms. Karabi, do we have the numbers confirmed for
I do.
Ms.? Thank you. This
I
is
do.
2400236. Those numbers are,
So we've got, Your Honor, rent owed in the amount of $1,789.80 plus court costs of $231.71 for a total of $2,021.51. And Ms. Carmody has agreed that she will be paying $1,400 on the third of each month, including the current month's rent, until paid in full. Ms. Carmody also waives the 56-day rule, and I have not asked her permission to sign on her behalf yet.
I'm sorry, you said you have asked her permission?
I have not.
Okay. Ms. Carmody?
She said your name.
Yes, Your Honor.
Were you able to hear the attorney just now?
Were you able to hear what the attorney said?
Yeah, I really can't. I'm hard of hearing. That's why my son's here.
Okay.
The
What
attorney
she just
basically-
indicated is that there's $1,789.80 in rent due and owing. There's $231.71 in cost, which is a total of $2,021.51.
$2,021.51 is what you owe.
Right.
And that's what you wish to agree to, ma'am?
To pay the $1,400 every month.
Every month, $1,400 for 4 months, and I'll be caught up.
Or until we're caught up, or you're caught up. Until you're caught up, right?
Ma'am,
Right.
okay. Ms. Karabi, the court's only concern is that if she owes $2,000, why would it be 4 months to repay it if
I
what she
didn't say,
pays is applied to the?
I didn't say 4 months, Your Honor, and it's also including the current month's rent that would be owed as well. So on the first of the month, she'll owe March rent and April rent. I believe it she'll be caught up, including her past due amount within 2 months. That's
She
why
should be
we,
called about 2 months, she's saying.
Yeah, maybe 2 months then.
Yeah,
that's why
Yeah,
we didn't
well,
put a definitive date, Your Honor, that we just put that until paid in full.
she didn't put an exact date, she just put it until paid in full.
Until paid, okay.
But she's saying it's looking
Okay.
like it's about 2 months because this is all you owe. The judge asked her, why
Okay.
is it gonna take that long when that's all you owe? So
Right.
she's explaining to the judge what number she has written on.
Having had that discussion, ma'am, is that the agreement you wish the court to enter?
You wish the court to enter?
Yes, that's the agreement.
Typically, when the parties are standing here, they can sign a judgment and present it, but because you appear on Zoom, there's not a signed agreement. Do you authorize Ms. Korabi's office to sign your name to the agreement?
Since you are not in court, typically they would have you sign an agreement in court, but since you are not in court, do you authorize them to sign your name for this agreement?
Yes, I do, Your Honor.
Thank you. They'll sign it and file it. I'll sign it and a copy will be mailed to you at the address we have on file, okay?
She'll sign it and a copy will be mailed to you to the address they have on file.
Okay, well, thank you.
Thank you.
Thank you so much, ma'am. You have a good day, and son, thank you for your help again.
Thank you all. Thank you,
Thank
Your
you,
Honor.
ma'am.
You have a great day.
Thank you.
Bye-bye.
This is 2400223 LT, Willow Country Estates versus Helen Keith.
Good afternoon, Your Honor. Douglas Swadish appearing on behalf of the plaintiff.
Thank you, Mr. Swadish. No response from the defendant. The court has received proof of mailing and proof of posting by the plaintiff. The case was scheduled at 1:30. It's now 1:46 by the court's clock. Helen Keith. There's no one in the session. There's no unidentified persons in the session. Based on the defendant's failure to appear, sir, how would you like to proceed?
Your Honor, the plaintiff would request a default judgment for possession only. The total amount of rent owed to retain possession is $22,575.
Court will enter that default judgment. Please present it through on base. This is 2400226 LT, Willow Country Estates versus Timothy Shepard. I note your appearance.
Good afternoon, Your Honor. Douglas Swadish appearing on behalf of the plaintiff.
I'm sorry, were you starting to say something else?
No, Your Honor, that's what I was just going to give you my appearance.
Okay, we appeared last time on January 26th, and it was not the named defendant. It was the wife/occupant. She was advised of this new date and time on the record being 1:30. It's now 1:48 by the court's clock. Neither the named defendant nor the occupant have appeared, sir. Based on their failure to appear, how would you like to proceed?
Your Honor, I will, for the record, inform the court that I did speak to the occupant, Robin Shepard. Her and I have spoke since that last hearing, and my client has agreed to enter into a new lease agreement with her only for this particular premises. So as such, we would, at this point in time, the plaintiff would ask for a default judgment as to Timothy Shepard only, the named tenant in the lease agreement. The judgments for possession only. The total amount of rent owed for him to retain possession is $18,475. And then with respect to Robin Shepard, the occupant, we would ask the court to enter a conditional dismissal. The conditions are that she would have to enter into a new lease agreement with the plaintiff within 10 days. The rent would be $950 a month. The lease term would be for 1 year, and there'd be a security deposit of $950. Ms. Shepard did agree to these terms when her and I spoke earlier today, and I did inform her that I would be appearing today and asking for the conditional dismissal with those terms.
Respectfully, sir, I don't believe that I have the authority to enter a conditional dismissal that establishes a lease for an unnamed occupant.
Is
as
that,
part of a non-payment of rent.
Your Honor, I respect that. I guess in that case, I would ask if the court will indulge us and adjourn this for 2 weeks to allow Ms. Shepherd to sign the lease agreement, and then we would take a default against Mr. Shepherd at that point in time and a dismissal against Ms. Shepherd.
Thank you, sir. February 22nd at 2 p.m. If you reach, well, I'll see you on February 22nd at 2 p.m. in this
I
matter.
think so, Your Honor. You said 2 p.m., Your Honor?
Yes, sir.
Thank you.
Is that it for you this afternoon?
It is, Your Honor.
Thank you, sir. You have a good day.
Thank you, you too.
Two four zero zero two two nine LT, Bill Properties versus Delmont Redeemer.
Laura Kubiana on behalf of plaintiff.
State your name for me, please, sir.
Delmont Redeemer.
Good afternoon, sir. Today is the day and time scheduled for the adjourned hearing in this matter. Sir, have you made an application for rental assistance?
No, not yet. If I need to, I would do so ASAP today.
Would you like the opportunity to speak to the attorney for Bill Properties?
Well, I would like to, if there's an opportunity for me to make payment arrangements.
Yes, sir. That's why I'm saying if you would like to, you can go into, there's a private virtual room for you to go into to speak to the attorney about that.
Okay. Yes, I would like to do that.
Then you'll see a message pop up on the screen to go in there. She'll be in there momentarily. She has one other case that I need to call, but she'll
Okay.
join you in there in just a moment. This is 240022, I'm sorry, 2400233 LT, Park Estates versus Chambers.
Laura Kubiana on behalf of plaintiff.
This is Stacia Chambers.
Ms. Chambers, the last time we were here, you indicated that you'd be applying for rental assistance. The court has received the form from you. What is the status of your application for assistance, ma'am?
I have received the approval and I am awaiting an answer on the date, and I got the approval for 1,300.
Would you like the opportunity to go into a breakout room with the attorney to discuss what that looks like, the rental assistance payment along with what you owe and your payment?
Absolutely, thank you.
You'll see an invitation to go into a room. Please go there, speak with her.
Yes, ma'am.
Thank you.
Your Honor, do you want me to wait or do you want me to go in the breakout room now?
You can go ahead. Those are the 2 o'clock cases. They can wait a
You
little bit.
got it. Thank you.
Thank you.
The person identified as Kim, can you connect to your audio? I'm trying to get you into a breakout room, please. Okay, I
Ms.
know who you
Kobish.
are. Yeah.
Sorry, I'm trying to do this on my phone as I'm also in a court case up and
No worries.
Judge Oakley's.
Okay, so I got you in there right now. I don't know if they're ready for you yet. They'll give you instructions. If you want, you can have a seat, or if you want some more privacy, you can go out to your car.
Oh, okay.
If you have any problems, I'll be right.
Okay.
Ms. McCann?
Yes.
We have not seen the attorney's office as of yet.
Okay. I know when I met with you last time, you guys were saying for me to get the DC form. I did get that filled out for approval for the Salvation Army, and I did put
Yes,
in the
ma'am.
state of emergency relief for DHS. I did put both of those in, and I did print the document off. I ended up coming in. She didn't end up emailing it to me until almost Friday night, Saturday morning from the Salvation Army, her half.
Miss McCann,
Yes.
I don't want to cut you off, but I see that you're in the lobby and the attorney is not here yet. So I haven't really called the case.
Oh, okay.
But I'll ask
Yeah.
you for the update. I'm sorry, go ahead.
Oh yeah, I came in because I was trying to use their computer because last time we met, I got kicked out. I couldn't hear you guys very well.
I understand. I appreciate that. Thank you.
No problem.
Are you busy? Could you bring Miss McCann up here into the courtroom, please? Thanks. Bye.
Yeah. Oh.
You have a case today?
Yes. Every case. I'm supposed to be at a doctor's appointment with my kid.
Well, we'll try.
Ma'am, you need to disconnect your phone. That's okay. Otherwise, we'll get feedback. We only have one video room and there's somebody in it and he's still waiting to be seen. So I'd rather you just come up here so we can talk. 2400-250-LT. The attorney is not here yet, but you've made an application for rental assistance.
Yes.
What's the status of your application?
I heard back from the Salvation Army. They have gave me their half of the documentation stating that they were in touch with Propel Property. I think they have paid a balance of the past due balance of $478. And then I'm also still waiting to hear from DHS because my daughter is previously about to have a surgery. She has tumors, and I have already been in touch with Propel Property to let them know that. So I had already applied for this stuff already like months ago.
Okay.
And they had knew that already previously, but I did let them know too. I filed taxes early, so I will be getting my refund back because I'm gonna have to pay up for the next couple of months with my daughter having that surgery.
What time are you due at the doctor's?
We have to be at a meeting today at 3:45.
Okay, I need you to do me a favor. You can stay in the courtroom. I'm gonna have you sit for just a minute. Give Mr. Devlin a moment to get here, maybe 10-15 minutes. And if he's not here, I'll let you go on with your day, okay?
Okay.
Thank you.
Thank you.
Back on the record with Chambers. This is 2400233. The parties have had the opportunity to speak. How are we proceeding?
Yes, Your Honor. With respect to Ms. Chambers, the parties have agreed to enter into a consent judgment for possession only with rent to retain in the amount of $3,746.09, court costs of $194.27, for a total of $3,940.36, with a payment plan as follows. Ms. Chambers will be paying $2,300 by February 16th and shall pay the remaining balance by February 29th. So we will extend the writ date till the 29th.
Thank you. Ms. Chambers, were you able to hear Ms. Karabi just now?
Yes, ma'am.
And ma'am, you were here back on the 26th. You saw the video that explained the rights you had available to you.
Yes, ma'am.
And you also received a paper copy of that advice of rights with the mailing of the summons and complaint.
Yes, ma'am.
And ma'am, you understand? That if the court enters that consent judgment this afternoon, you won't have any additional hearings as relates to the amount of rent claim due and owing.
Yes, ma'am.
You wish the court to enter the consent judgment that she just placed on the record.
Yes, ma'am.
Do you have any questions about the rights available to you or these proceedings?
Not at this time, no, ma'am.
Thank you. Then, ma'am, the court will enter the consent judgment that Ms. Karabi presents to the court electronically. Copy will be mailed to you at the address we have on record. Anything else on behalf of the plaintiff?
No, Your Honor, thank you.
Thank you. Anything else for the defendant? Anything else, Ms. Chambers?
No, ma'am.
Thank you. That concludes this matter. Have a good day.
Thank you.
Ms. Karabi, did you speak to Mr. Redeemer?
Did, Your Honor, he had requested a payment arrangement, but I haven't been able to get a hold of my client to approve that.
In 2400229 LT, Bill Properties versus Redeemer.
Laura Kruger, Your Honor, on behalf of plaintiff.
Thank you. So you were saying, Ms. Karabi, that he wants a payment plan. You haven't been able to get a hold of your client. What's the payment plan and what's the rent to retain possession?
Rent to retain, Your Honor, is $2,038. Court cost is $181.68 for a total of $2,219.68. And he was requesting to pay half of his balance by February 14th and the remainder on February 28th.
On February 20 what? I'm sorry.
28th.
So, Ms. Karabi, are you looking for the court to enter that as an order or adjourn the matter for you to get a hold of your client and come back on the 22nd?
Your Honor, we don't have to adjourn it. If you are okay with extending it till the 28th, I have no problem.
Mr. Redeemer, were you able to hear the attorney just now place the amount of rent claim due and owing on the record?
Yes.
Is that amount correct? $2,038?
Yes.
And you understand that the plaintiff is entitled to a cost of $181.68?
Yes, I am. Yes.
And sir, if the balance is split in half with half due on February 14th and the other half due on February 28th, you'll be able to pay those amounts?
Yes.
Mr. Redeemer, inasmuch as you admit and agree that the amount claimed due and owing is accurate, the court will enter it as a judgment after hearing with an order that indicates that the payment of the judgment will be split in half, half on the 14th, half on the 28th. Her office will submit it to the court electronically. I will sign it and a copy will come to you in the mail. Do you have any questions about today's proceedings, sir?
No, ma'am.
Thank you. That concludes this matter, Mr. Redeemer. You're free to go. You can exit out that door to your left. The court staff will come reset the computers. Thank you.
All right. Thank you.
Your Honor.
Ms. Karabi, you have quite a number of cases scheduled at 2 o'clock. I'll take Mr. Devlin's case. Mary Ann will get your 2 o'clock and the 2:15 tenants moved into your waiting room, okay?
Thank you, Your Honor.
Thank you. Mr. Devlin in 2400250 LT, Ms. McCann is here in the courtroom.
Yes, Your Honor.
She has applied for rental assistance and has indicated that her application is pending with DHS.
Okay.
Was there something you wanted to say, sir?
No, there's nothing to add. I mean, I'm assuming she's provided the requisite documents to the court.
Yes, sir.
Perfect. When would you like to adjourn to?
The 22nd at 2 p.m.
Very good, Your Honor.
I'll see you then. Thank you, Mr. Devlin. Did you have anything else this afternoon, Mr. Devlin?
Sorry, Your Honor. No, I was just putting it in my calendar before I logged off.
Oh, no, I was just asking you because I wasn't looking at 2:30 yet. Have a good day, sir.
You as well.
Thank you. Ms. McCann, I'm sending you back downstairs. Please stop at the counter for the civil department. I've sent a message downstairs for them. Okay. They'll make sure that you've done everything you're supposed to do, and I will see you back here on the 22nd at 2 p.m. They will mail notice to you of that new date and time, okay?
Okay, thank you.
Have a good day, ma'am. Thanks, Ken. Miss Zanin, good afternoon.
Good afternoon, Judge. How are you?
I am super. How have you been?
I'm fabulous.
You're a little bit early unless you're covering for someone else.
No, my notes in my system from my office said, make sure you get on 15 minutes early. And I'm always slotted in so many extra courts that this time I could actually make sure I got on 15 minutes early. So I did.
You're scheduled at 2:30, so we're still sloshing through the 2 and the 2:15.
That's fine. I'll just hang tight. Thank you.
Okay. Ms. Miller, we're waiting for Mr. Katz. Your case was scheduled at 2:15. He was here this morning.
And Your Honor, Alexa Metner here. I represent Ms. Miller. We did submit a conditional dismissal on Monday. So that might be the reason he isn't here.
Okay, give me 1 second. I don't see it. Let's look in on base and see what we see. Did you submit it or did his office submit it?
I submitted it on my file.
You submitted it through on base?
Let me see how we submitted it, because we can resubmit it.
Oh no, that'll make it worse.
Okay, I won't.
Okay, here it is, 24251. Oh, yep. Conditional 2400251 T Maxwell versus Miller. There is a signed conditional dismissal in the judge review queue, signed by Ms. Methner and Mr. Katz. I will affix my stamp to it right now and send it back to the clerks for processing.
Awesome, thank you.
Anything else, Ms. Methner?
Nope, that's all.
Thank you, Ms. Miller. That concludes this matter. You'll get a copy of that signed conditional dismissal in the mail. Thank you for your patience this afternoon. Have a good day.
Okay, thank you.
Thank you.
You're welcome.
Something about 15-minute prior login.
Yeah, so there we go.
Okay.
Ms. King, the attorney is here for Yes Swan Creek.
Yes.
Do you need to go into a breakout room, Ms. Zanin?
We can, Judge.
Thank you. Ms. King, you'll see an invitation to go into the virtual breakout with Ms. Zanin to discuss this matter.
Thank you.
Thank you.
So. Ms. Ruiz, please join the breakout room.
How do I do that?
Something should have popped up on your device to join breakout room.
No, I didn't see anything. Still nothing popped.
Okay.
Good afternoon, Ms. Thomas.
I'm all right. And yourself?
I am well, thank you. We are waiting for the representative from Mr.
Yeah.
Rabbit's office.
Okay.
Good afternoon, Mr. Novak.
Judge, good afternoon. How are you?
I am super. How have you been?
I'm okay. I understand you were talking to
Miss
Katie
Thomas.
this afternoon.
Yes.
Katie is such a sweetheart. I'm
She
lucky to
is.
have her.
Miss Thomas, this is the attorney for Mr. Ravitt's office for Birch Run. Do the parties need to
Okay.
speak?
Yes, please.
We'll get you moved into a breakout room. Miss Thomas, you'll meet with Mr. Novak.
Okay.
Thank you.
So just stay online?
You'll see an invitation going to another room. You'll go into a private virtual room with him.
Okay.
Thank you.
You're welcome. Thank you.
You're back already?
Yeah, Judge,
Yep,
it's
we're
my
back.
understanding Ms. Thomas is working with an agency to come up with some money. So how about if we adjourn it for a couple of weeks? I think it's required under the court rule.
Thank you. Miss Thomas, were you able to hear Mr. Novak just now?
Yes.
Ma'am, this case will be adjourned over to the 22nd of February at 2 p.m. At that time, you'll need to provide an update regarding your applications for rental assistance, okay?
Okay.
Anything else, Mr. Novak?
Nothing further. Thank you, Judge.
Anything else, Miss Thomas?
No, thank you, Judge.
Ma'am, you're free to go. You have a great afternoon.
All right, thank you.
Good seeing you, Judge.
Bye-bye.
Thank you.
Take care, sir. Miss Morris, have you spoken to the attorney for Trilogy yet?
Not today, I haven't.
Okay. Ma'am, I show that you were applying for rental assistance. Which agency did you apply with?
I applied online with the SER.
Have you received a response?
I have not.
Did you file the form with the court, the DC 539?
I did not, because I thought I was supposed to have the paperwork from the SER form. I thought I was supposed to have some paperwork attached to it. I even tried to call in the court, but it just kept hanging up on me every time I called.
Okay. This is 2400253 LT. This is Yeswan Creek versus Sean Potter. May I have your appearances, please?
Good afternoon, Judge Carrie Zanin, P67390 on behalf of plaintiff.
Ma'am, state your name for the record, please.
Lisa King for Sean
Thank
Potter.
you. Today is the day and time scheduled for the adjourned hearing in this matter. The parties have had the opportunity to speak. Ms. Zanin, how are we proceeding?
Judge, I am asking for default as to defendant 1. As to Lisa King, an occupant, we have agreed to a consent judgment for possession only, an extended writ issue date of February 26th of 2024. I've explained to Ms. King her rights under MCR 4.201J, her appeal rights. She has given me permission to sign this consent judgment on her behalf as we are virtual, and I would ask that Ms. King put that on the record as well, that she has given me permission to sign this consent judgment on her behalf and submit it to the court for entry.
Is that correct, Ms. King?
Yes.
Ms. Zanin, I'm showing this as a non-payment case. Is it something different on your end?
Yes, Judge, I'm showing it as a termination case. I have a
Give me one
30-day
moment.
notice to quit.
It's because my husband passed away and I'm only considered an occupant and they don't want to allow me to live on the property even
Judge,
though
I would
I
object
don't
to
know where to
her
go.
testifying to this information at this
Ms.
point.
Ms. King, respectfully, the issue is that it's miscoded in our system. Ms. Zanin, the terms that she placed on the record indicate to the court that it's a termination case, but the way it's labeled suggests that it's non-payment. And I just wanted to make sure that we were entering the correct information. I pulled up the paper version of the file and I see that it should be a termination of tenancy. Now, Ms. King, you were here back on January 26th, and there was a video that played that explained the rights available to tenant proceedings. Do you remember that?
Yes.
And when documents were mailed to the court regarding this, were mailed from the court regarding this case, it included a paper copy of that advice of rights form. Do you remember receiving that document?
Yes.
And you appeared this afternoon and you entered an agreement with Ms. Zanin that you would vacate the property by February the 26th.
If I'm not able to get, yeah, I mean, I'm doing the best I can. I'm trying to find some place to go. I've pretty much exhausted all my options and I'm still not having a place to go. So also with that, I'm aware that there's a class actions lawsuit against Yes Properties, and I tried to use legal aid to get assistance and attorney, and it didn't work for me. I don't know, I had a really hard time using that option. So I'm kind of not sure on what to do, you know? I mean, I don't have really a whole lot of choices, so I guess I'm accepting the date set, but you know, I'm not finding anywhere to move out to. So I'm kind
Ms.
of.
King, respectfully, this court can only address the matter that's scheduled with it this afternoon. And Ms. Zanin's representation to the court is that the parties are agreeing that you will vacate the property by that date. I go over the fact that the advice of rights has been given to you in multiple fashions because when I sign a judgment, there's a box that has to indicate that you're entering into this consent judgment freely and voluntarily. That being the case, ma'am, is it your agreement this afternoon that you will vacate these premises by February 26, 2024?
Right.
Then Ms. Anna's office will prepare a consent judgment that indicates as much, submitted to the court by the on-base filing system. I will sign it and a copy will be mailed to you at the address we have on record. Is there anything else in this case, Ms. Anna?
No, Judge, thank you.
Is there anything else, Ms. King?
I guess not.
Then ma'am, you may exit that room by the door through your left. The court staff will come reset the computer. Thank you, ma'am. Have a good day.
Thank you, Your Honor. Have a wonderful day.
You too, ma'am. Ms. Karabi.
Hello. Oh, actually, Your Honor, I'm sorry. I believe I see one other individual that I didn't speak to.
Oh, ma'am, you have a breakout room full of people.
What is it?
Oh, yeah.
Okay.
Hello?
Yes, ma'am, you
Yes.
need to join the breakout room, please.
It popped up, but every time it pops up, I can't hit it. There we go.
Marianne, why does it still look like we have 20 cases?
That are in the waiting room, you mean?
I'm looking on the bench, in the bench files.
Oh.
That cannot be right. 24002430LT, Huron Estates versus Shauna Ruiz and Brandon Fondren.
Laura Kubian on behalf of plaintiff.
Yes. I'm
State
here.
your name, ma'am.
Shonda Ruiz.
Thank you. Today was a day and time scheduled for the adjourned hearing in this matter. How are we proceeding?
Your Honor, we did have an opportunity to talk, and we were proceeding with a consent until Ms. Ruiz informed me that she would not be able to pay until the 29th. I do not have any authority to extend the writ date, but there is no dispute over the amount that is owed at this time.
Ms. Ruiz,
Yes.
would you please put your face in the screen and confirm what Ms. Karabi just said?
I do not have a camera. It's still broken. I told you that last time I talked to you. I just know I talked to the manager and they put it in the thing or put it in my paperwork at the trailer park. They told me to go ahead and go to the court date and tell you that's what I was gonna do and just not to miss the court dates. They said it was fine with them, but I guess they didn't say anything to her yet.
It was fine with Huron Estates for you to pay on the 29th?
Yes, because I'm just waiting for my taxes to come in. And that it would be paid
Ms.
before the
Karabi,
end of February.
Yes, Your Honor.
What's the rent to retain possession?
It is $4,033.86 plus court costs of $231.71 for a total of $4,265.57.
Ms. Ruiz, is that amount accurate, the amount of $4,033.86 in past due rent?
Yes.
Ma'am, then the court will find that there is no tribal issue of fact to enter judgment after hearing. In that amount, plaintiff is entitled to recovery of court costs of $231.71 for a total judgment of $4,265.57. Over the objection of the attorney, the court will extend the writ date to February 29th, ma'am, which means you need to have that amount paid in full or vacate the property. Partial payment will not prevent the writ from issuing in this matter. Is there anything else on behalf of Huron Estates?
Yes, Your Honor. At this time, we are also requesting a default judgment as to defendant Brandon Fondren with the same terms.
Absolutely.
Thank you.
Anything else, Ms. Ruiz?
Nope. Thank you so much.
Thank you, ma'am. You're free to go. You have a good day. Ms.
You
Karabi,
too.
there are 5 people waiting to speak to you. And before you go, we have cases where there is mail but no posting or personal service. And if any of those defendants appear, I will hear the case or connect the parties. Otherwise, those cases will be dismissed for lack of service, okay? We'll go over that list of cases when you're finished.
Your Honor, I did speak to everyone in the waiting room already. I just did not.
I'm
bring them
sorry,
back
give
in.
me one second. This
Okay.
is Judge Martin. How may I help you?
I can, Ms. Karabi, I can bring them out.
Yes, ma'am.
Thank
Would you
you.
send it over for me, please? Thank you. I'm sorry, Ms. Karabi, when criminal cases call, they take precedence. You were starting to say you've talked to the people in the office and
I've already spoken to everyone that's on Zoom right now. With respect to the service, I do know that service was sent out with the process server and confirmed on January 26th, but we just haven't received our proofs of services back.
okay. Let's start with I think Mr. McClellan was the 2 o'clock case. The first person I saw, 2400240LT, Huron Estates versus McClellan. Sir, would you state your name for me, please?
Thomas McClellan.
Sir, the way the court staff have you labeled indicates that your application for rental assistance was denied. Is that correct?
Yes, ma'am.
You've spoken to Ms. Karabi.
Yes, ma'am.
How are we proceeding?
Your Honor, at this time, the parties are proceeding via consent judgment for possession only, rent to retain in the amount of $2,381.54 plus court costs of $181.68 for a total of $2,563.22 with a writ date of February 19th, 2024. I have been informed by Mr. McClellan that he does not have the funds to get this paid and will be moving out by that date.
Mr. McClellan, is everything that she said accurate, sir?
Yes, ma'am.
Mr. McClellan, when you were served with the summons and complaint in this matter, it contains an advice of rights form. Do you recall receiving that form?
Yes, I do.
Sir, do you have any question about the rights that are available to you in this proceeding?
No, ma'am.
Do you have any questions about the consent judgment?
No, ma'am.
Then Ms. Karabi's office will prepare a consent judgment with the terms she just placed on the record. It will be filed electronically. I will sign it, and a copy will be mailed to you by court staff in just a few days. If you have no questions, Mr. McClellan, you're free to go, sir. Good luck to you.
Thank you very much.
This is 2400255 LT Trilogy Residences versus Anthony Best. Mr. Best, state your name for the record, sir.
Yes, Anthony Best.
Mr. Best, you've had the opportunity to speak to Ms. McCarabi for Trilogy Residence this afternoon.
Yes.
Ma'am, how are we proceeding?
Your Honor, the parties have also agreed to a consent judgment with rent to retain in the amount of $4,602.98 plus court costs of $181.68 for a total of $4,784.66 to be paid by February 19th, 2024.
February 20th. 19th is a holiday.
Okay.
Mr. Best, you appeared in court back on January 26, 2024, and there was a video that played that explained the rights available to you. Do you recall that, sir?
Yes.
And you were also served with a summons and complaint, which contained a paper copy of these advice of rights. Do you recall that, sir?
Yes.
Do you have any questions about the terms of the consent judgment that were placed on the record this afternoon?
No.
Do you have any questions about these proceedings?
No.
Do you wish the court to accept the consent judgment with the terms placed on the record?
Yes.
The court will enter a consent judgment with the terms that Ms. Korabi placed on the record. She will file it electronically. I will sign it, and a copy will be mailed to you at the address we have on record. If there's nothing else, Mr. Best, you're free to go. You have a good day. Good luck to you.
Thank you.
You're welcome. This is 2400259 LT Trilogy Residences versus Nicole Morris. Ma'am, state your name for me, please.
Nicole L. Morris.
Ms. Morris, the last time we appeared, I think my notes indicated that you were applying for rental assistance. Is that correct?
That's correct.
And the status of your application with DHS?
I don't know yet because I was supposed to get some information through the mail, but I haven't received anything yet.
Did you speak to Ms. Korabi this afternoon?
Yes, ma'am.
How are we proceeding?
Your Honor. Oh, go ahead. I'm sorry.
I'm sorry. You go ahead.
Okay. Your Honor, we were in talks of a consent judgment. However, Ms. Morris was unsure whether she can get that paid by the 19th of February, and I do not have authority to extend that date. I believe she wanted an additional week.
Ms. Morris, my concern is more that you have an application for rental assistance outstanding. There's only been one adjournment of this matter. I will put it over to the 22nd at 2:15 p.m. If in the interim you're able to you receive the approval from DHS, I would suggest that you're in contact and communication with the landlord. Otherwise, I will see you back here on February 22nd, 2024 at 2:15 p.m. Okay?
Absolutely.
Thank you, Your Honor.
Anything else, Ms. Morris?
No, ma'am. That helps me out.
Thank you, ma'am. Have a good day.
You too.
Two 2400238 LT Huron Estates versus Lanika Jones.
Good afternoon.
State your name, ma'am.
Lanika, it's actually Lanika K. Jackson. I'm divorced now. I'm not Jones anymore.
That might just be the name on the lease, ma'am.
Yes, it is.
Have you applied, ma'am, Ms. Jackson, have you applied for rental assistance?
Yes.
With what agency, ma'am?
MDHHS.
When did you make that application?
About 5 to 6 days ago. It was last week.
Do you have an update regarding the status of the application?
No, I've been checking the status. All I received so far was a tracking number.
Thank you. Ms. Karabi, the court will adjourn this matter. The case was first scheduled on January 26th. At that time, the court did not show mailing or posting or service by the plaintiff's office. This would be the defendant's first appearance. Ms. Jackson, this case is being adjourned over to February the 22nd at 2:15 p.m. back at the same Zoom. Court staff will mail notice to you. When you appear on the 22nd, please be prepared to provide an update regarding your application for rental assistance and be ready to have a discussion with the representative for Huron Estates regarding how you will satisfy the outstanding rent due in this matter, okay?
I do have a question. The attorney that's representing Huron Estates, she said that I would need a DRC form.
It's called a DC 539.
DC 539,
And you, ma'am, you have 5 days from today to file that. There's court staff on right now. I can move you into a breakout room. You can talk to that person and she can explain how to access that form if you need assistance.
Okay, and one last question, Judge. What is that form? Actually,
it's a new form. It's a new form developed. There's some new court rules, and there's a new form that is I don't even know how to explain it. It's the formal notice to the court and to the plaintiff's attorney that you have this application for rental assistance outstanding.
Okay. All right.
That's all. It's a new form. We're all getting used to it. It's on our website, but there is someone here, a court clerk named Carly. She'll go into a breakout room with you and explain to you where you can find it on the court's website, and you can submit it electronically. You don't need to physically come to court to do it.
Okay.
Okay.
All right. So,
Anything
I'm
else,
sorry.
Ms. Jackson?
Yes.
Go ahead.
I'm sorry. When did you say that we will be back?
February 22nd at 2:15.
And is it the same Zoom ID?
Yes, ma'am.
Okay. That'll be all, Judge. Thank you.
Thank you, Ms. Jackson. Let's go have you get in with Carly. She'll take you to that form.
All right. Thanks.
Thank you. Ms. Pritchett. Sophia Pritchett. Two 2400265 LT Trilogy Residence versus Justin Walker.
Yes, hello.
No, sir. No. State your name.
I'm sorry, Justin Walker.
Thank you. Mr. Walker, have you made application for rental assistance?
No, I'm going to today.
Ms. Karabi?
Your Honor, that is exactly what he told me as well. He did tell me that he was going to be paying $1,100, I believe, by, did you say this Friday, Mr. Walker?
Yes.
Yeah.
This Friday, the
9th.
Then, Mr. Walker, what you need to do, if you're making an application for rental assistance, there is a form that you need to complete and file with the court. It's called a DC 539. It is on the court's website, but there is court staff available to explain to you how to get to that form. You can fill it out, submit it electronically. You don't have to file it in person. You're more than welcome to, but you don't have to. That form has to be filed within 5 days of today's date. Understood?
Yes.
And sir, your case will be adjourned over to February the 22nd at 2:15 p.m. When you reappear in this case, please be prepared to provide an update regarding the status of your application for rental assistance, or be prepared to discuss with the attorney how you will resolve the outstanding rent that's due in this case, okay?
No problem.
Anything else, Ms. Karabi?
No, Your Honor, thank you.
Anything else, Mr. Walker?
No.
I'll see you on February 22nd, sir. Have a good day.
Thank you, you too.
Thank you. Now, at 3 o'clock. Ms. Karabi, here's what I show remaining are 2400-264 LT, Trilogy versus Darius Timmons.
Mhm.
The court shows no service. No service, the defendant did not appear the first time, did not appear the second time. So this case will be dismissed. There is 2400-244 LT from the 2 o'clock docket, Huron Estates versus Courtney Solinger and Stacy Klaus.
For that one, Your
We
Honor.
show court mail and,
Oh, sorry, go ahead.
I was gonna say, we show court mail and we show mail by your office, but we don't show posting or personal service.
I have all of them. I just don't have them. I have record that they were served. I just don't have the actual copies. I don't want this dismissed. Can we?
I
there's-
understand, but here's the thing, when Miss Lacy was here, your office wasn't the only office that there was an issue with. And what I advised previously is that I would enter a default if the plaintiff could produce proofs that these things were timely done. When Miss Lacy was here on the 26th, she couldn't even confirm that service had happened, which is the reason why your cases were adjourned over to today. And I since have gone back in every single file to make sure that we have what was necessary and required, and we didn't in all the cases. And I think that some of these tenants appeared because
They called the court.
Not because they called the court, but because there was court mail and then notice to appear today. But even with the court staff sending out notice to appear for the second hearing, in my opinion, it doesn't cure the defect of there not being service made. So if there's service, it should have been filed sometime in the last, if I hear this door open one more time.
It's been a day, Your Honor.
Service should
It's
have
been a
been,
day.
it should have been added to the file. And I hate to do it as we work through these hiccups, but I can't cure the defect of service with notice from the court. So that's, if your office files it and files a request to reinstate and all other good stuff, I'm happy to do it. But for right now, the court will dismiss this case.
With respect to the case you just called, Your Honor,
Schlosinger and Klaus, Solinger
Yes,
and Klaus,
I'm not here. However, I do have a signed consent judgment and advice of rights form from the tenants from this morning. I don't know why they're not here, though. Are you willing to accept that, or does it need to go on the record with both parties?
Wait, you have a signed consent judgment and a signed advice of rights form that you received this morning for a case that was scheduled at 2 o'clock today?
That is correct. I have I mean, it's not signed by you. It's a proposed consent judgment, Your Honor.
I know what you mean. If you have it, send it over. File it on base. I'll make a note to myself. When the staff send it up to me, I'll look at it. And then there's 2400-242 LT, Huron Estates versus Leah Radke and Robert Radke, same thing. First hearing date was January 26th. There's been mail by court and by the plaintiff, but there's no posting, no proof of service, no proof of personal service or proof of posting in these matters.
I apologize, Your Honor. Can you give me the last name one more time for that case?
Can I give you the last what?
The last names of the defendants for that case.
Radke,
Oh, okay.
Radtke. 2400-237 LT, Huron Estates versus Keith Dyer and Harvey Fry Jr., same thing. Mail, but no proof of posting or proof of personal service, is originally scheduled for January 26th. The court adjourned the matter for the plaintiff to produce the proofs. There is proof of mailing, but no proof of anything else, and the defendant's not appearing. Court will dismiss this case for non-service. 2400-234 LT, Park Estates versus Haley Wilson. This case was scheduled at 1:45. It was originally scheduled on January 26th. There was no service in the file. The court has since received proof of mailing, but there's no proof of personal service or posting. The case will be dismissed. And then 2400-228 LT, Bill Properties versus Cecil Coleman and Katie Cruz. Case was originally scheduled for January 26th. There was no service in the file. The court adjourns the matter to today's date for the plaintiff to file its proofs of service. There is proof of court mail, but there's no proof of any other mail in the court file. The court will dismiss this case for non-service. Last case is 2400257 LT Trilogy Residence versus JK Julias, Gulyas. This case was originally scheduled for January 26th. There were no proofs of service in the file. There's proof of court mail in the file now, but no other proofs. Based on that, the court will dismiss this matter for non-service. And Ms. Kohlrabi, just so we're clear, and if next time Ms. Lakes or anyone else from your office appears, I'll advise the same. If the defendants appear, although there may be defects in the service, the court will conclude that they received service by some other method, whether it's the court mail or plaintiff's mail. But when they don't appear at all, and there's no indication they've been in contact or communication with the court regarding the file, those are the only instances where I will dismiss the case. If you find that your office has proofs of service that show that either posting or personal service were made in these matters before that first hearing date, the court will entertain and look favorably upon a motion to reinstate and enter default judgment. But short of that, I don't know a better way to proceed.
Okay, Your Honor, there are two more though that I have. I don't know if you called them or not. I have 2400195.
195, give me 1 second. Oh. That's from, oh, I'm sorry, ma'am. I missed the 1 o'clock doc in its entirety.
That's okay. Just two more.
Huron Estates versus Nicholas Derminer. Same thing. There's court mail, there's plaintiff mail, but there's no proof of posting or personal service. And then 2400206, Huron Estates versus Jason Rusty Nichols, same thing. Case was originally scheduled for January 26th. There was no service in the file. There's plaintiff mail and court mail, but there's no personal service or posting. The defendants have not appeared this afternoon. The court will dismiss the matters.
Okay, thank you, Your Honor.
Thank you, ma'am. Have a good day.
You too.
Thank you, Carly.